Is like, are they supposed to supply that, especially with me being the primary caregiver? And you know what I mean? I'm just kind of confused. And we haven't had our jurisdictional hearing or trial yet, which is coming up. But it just doesn't make any sense. They're not providing us any reunification with him.
We're going to take another call, and this time it's from Lacey in California. Oh, Lily. I'm sorry, Lily in California. I had the name Lacey stuck in my head for some reason. Lily, are you there?
No problem. Yes, I'm here.
How are you?
Good. I kind of have two questions.
Go for it.
I have 6 kids. One of my kids, CPS removed and gave to the father. All the other kids are still with me. They have gave me no services to reunify with my son. I have full custody of him. His dad has no custody of him. He only gets visitation. I allow him to go Christmas and summers only. He's been with his dad now, I want to say, since, originally he was there to visit. So when this case opened, he was visiting his dad during summertime. Then when he was supposed to come back in August, that's when they removed him and put him back with his dad in South Carolina, because we're not in the same state. I'm here in California. I'm getting no reunification services. I want to know, my question is, like, are they supposed to supply that, especially with me being the primary caregiver? And you know what I mean? I'm just kind of confused. We haven't had our jurisdictional hearing or trial yet, which is coming up. But it just doesn't make any sense. They're not providing us any reunification with him.
Well, you know, you're supposed to be getting reunification services, to put you back with your child that was removed from you. And it's odd that you said that you have all your children except for this one.
Yes.
Was the child removed from you because there was an issue, perhaps between you and the child?
No. The case, when it was open, I didn't even have anything to do with him. I had to deal with my daughters. And then all of a sudden it kind of blew up, and now they're trying to say that I hit my son too. And my son, I've never hit my son. It's like I think they're trying to keep him.
Is your son making the allegation that you hit him?
Yes, but he didn't make it until August when I tried to go bring him back.
How old is he?
He's 12.
Mm-hmm.
He just turned 12 in July that year.
Well, are you represented by an attorney in your case?
Yes.
Okay. So what I would suggest is that you speak to your attorney either on the phone or via email and find out why they're not giving you reunification services.
Yeah, I have. She doesn't know why. I even asked the caseworker to come out for a meeting because I wanted to know what you guys are doing to reunify me and my son, and she said nothing. She's going to leave it up to the judge.
Okay. Did she put that in writing?
No, she didn't. She just told me verbally. But I called my lawyer as soon as it happened, as soon as she told me that.
You know, I think that you and your lawyer can discuss making some type of motion to force the county to provide you reunification services with your son.
Okay.
I don't know the case. I haven't reviewed it. I don't know why they left you with all of the children except for him, and he wasn't even the cause of the case being started. You know, that doesn't make a lot of logical sense. It seems like he should be in your custody, especially if you have custody under a family law order. So what I would suggest is that you email your social worker and or your attorney to find out, exactly why you're not getting family reunification services with your child that was removed from you and placed with his father.
Okay. And my second question is, they're trying to charge me for an incident that happened to my daughter that happened over 5 years ago.
Right.
Our case barely in May. So they've known about that incident because I had to report it to CPS as well in 2016. So why all of a sudden can they try to charge me for something that I was at work when it happened. So they're trying to get me for failure to protect, which doesn't make any sense to me either.
Right. So
when I took her to the police, I took her to counseling for it, everything, and they're still trying to get me for that.
Well, the reason why they're trying to do it, in my humble opinion, is that they don't have anything else against you. But what I would do is I would talk to your attorney about a case called In Re Rocco, R-O-C-C-O.
Hold on.
M. In Re Rocco, M.
In Re Rocco.
M.
And he said R-O-C-K?
No, R-O-C-C-O.
C-C-O. Okay, Rocco. Okay.
And what that case says is, if I remember correctly, is that the social worker, on the day of the trial, has to prove that the allegations present a current risk. Now, in my mind, something that happened 5 years ago, they're not going to be able to prove it's a current risk. I don't know all the facts, of course, but I'm just guessing. Something 5 years ago, they never did anything, and if they knew about it, they can't bring it, in my opinion, can't bring it back up 5 years later and say, oh, we got you on this one. So if I were you, I'd talk to your attorney about fighting that or making a motion to have it, thrown out. There is a case, and I don't recall the legal history of it, but there's a case out of, I believe it was San Diego County, that said, In Re Troy D, T-R-O-Y-D, that said that you can file what's tantamount to a civil demur against the petition filed against you, and basically argue that it should be thrown out because it doesn't state a cause of action under Section 300 of the Welfare and Institutions Code. So in this particular case, you and your attorney may be able to file a Troy D motion to have that allegation just thrown out. 5 years ago, and they knew about it all this time, that doesn't mean they can bring it up now just because it exists. That's 5 years. That's a substantial amount of time. I've seen cases where they've, held that it was okay, maybe 6 months, maybe a year, but 5 years? I don't think so. So talk to your attorney about the In Re Troy D motion. And according to that case, and I don't know if it's been changed subsequently, but according to that case, you could make that In Re Troy D motion anytime. The first hearing, the second hearing, anytime until the trial starts. And I think there was a case that said you could even file that motion and have it heard the day of the trial before the trial starts and have the court try to dismiss something that's just, totally ridiculous.
Awesome, because, our trial's coming up next month, so.
Yeah, so you might want to talk to your attorney about making that Troy D motion. If your attorney doesn't seem warm to the idea, I can give you and your attorney, of course, a templated motion, In Re Troy D motion, and maybe you can try to file it at that time. In later years, after I was doing Troy D motions, I got a lot of, I didn't get warm feelings from the court when I made those motions in a lot of instances because the judge, wanted to hear all of the evidence and, the whole story to try to make a decision. And that's the judge's discretion, right? They wear the black robes, they get to make certain decisions. But, if you want to, if your attorney wants a templated motion, I can give you guys one. Just call me, 888-888-6582. You might be able to use it, might not, but whatever you do, take the advice of your attorney, okay? Because he or she knows more about the case than I do. We've had an 8-minute conversation. Your attorney knows much more about the case than I do. I'm just throwing you out ideas that you might be able to use. Okay, Lily?
Okay. Thank you.
Thank you for calling. Thank you for listening. And, after the trial, call us. Give us an update and let us know what happened on your case, okay?
Okay. All right. Thank you.
Thanks. Hey, Cynthia.